I will be relying on the submissions and the petition as it is. However, I would just like to highlight 3 short things. The first issue, and this has been the position for over 40 years, since the time of Studley Munga Githunguri, the law has been always the same on the circumstances under which the court can review the decision of the ODPP or the Attorney General at that point to charge or to prosecute an accused person. Currently, the constitutional provisions which apply are 3. That is at 157, clause 9, at 157, clause 10, and clause 11. 9, 10, and 11. The decision of the Supreme Court in 2 matters have established the guidelines to be applied when the High Court is reviewing that decision of the ODPP. The guidelines were borrowed from the Indian Supreme Court case, that is R.P. Kapoor versus the state of Punjab. That is a 1960 case. I just want to mention the 4 guidelines which the Supreme Court applied or said should be applied. The first one, the High Court can review the decision of the ODPP to charge on the basis that it is an abuse of the court process, or that the quashing of the proceedings would meet the ends of justice. That is the first principle. And which we will be relying on in this case. The second one, which we will not be relying on in this particular matter, is where there is the lack of sanctions. For instance, sanctions, there is a legal back to the preferment of the charges or the continuation. For instance, if you charge a president, there would be a legal ban in that case. We will not be relying on that. The third one, which we will be relying on, is where the first information report does not excuse an offense. Where the first information report does not disclose an offense. And lastly, where the evidence produced is insufficient or cannot prove the offense, or there is no evidence at all. Those are the 4, and you will be relying on 3 of them. Now, if you may allow me, there is application of Article 157(9), and this is the provision which provides that the powers of the DPP may be exercised either in person by the DPP himself or by a subordinate. But when it comes to the subordinate, it is in accordance with general or specific or special instructions. The manner in which the DPP gives these instructions, given the scale, you have one DPP and there are so many subordinates all through, is by giving guidelines. And the guidelines given are the guidelines on the decision to charge of 2019. Guidelines on the decision to charge 2019. So in short, what the guidelines provide, where the Constitution provides for the general, which is abuse of court process, public interest, and so forth, the guidelines are so specific on the issues you must ensure. So if I may use an analogy, if the Constitution tells us that it is my responsibility to secure this courtroom, the guidelines you tell you when you are leaving the courtroom, close the door. These are the practical steps. And the practical steps are, one, ensure that the minimum requirements of the file are met. That is the first one. Ensure that the minimum requirements of the file are met. And details are given on what those minimum requirements are. They are the submissions. The second thing, ensure that the narrative of the complainant is congruent with the evidence in the file. So first, ensure that the file is complete. If it is not complete, the guidelines tells you to refer the file back to the investigator. If it is complete, you go to the second step, check the evidence, whether the narrative matches the evidence. The third is where you apply the two-stage test by checking the key evidence, whether it shows the culpability of the accused and there is sufficient evidence, and secondly, whether it is in public interest to charge that person. And finally, what the guidelines require is that if circumstances change so as to show that the charge is no longer sustainable, then the ODPP should review that decision. To shorten this, my lady, I don't know whether you can allow me to share a decision by Justice Shigiti. I hadn't shared it all. The reason it came up today is I was researching on the effect of non-response of the petition. The ODPP was to respond to the petition. He did not respond. This position covers that, and it also covers now the issue of the guidelines on the decision teacher and how they are applicable. Instead of reading it has. Yes, let me finish off. IDI on that decision, it is people is 3 days and allows you. Pardon? I'm very sorry. You have to have a case there. Yes, the decision speaks about the two issues. The first one, that the guidelines are applicable, and the Justice Shigiti Senior Counsel applied those guidelines to weigh the decision of the ODPP whether it was valid. And then the issue of failing to respond. If you look at the bundle, there's very many communications to the ODPP and the investigation officer from November 2024 requesting for the OB report. They were never responded. There is also a comprehensive communication seeking for review of the charges. Again, this is not responded to. So that decision handles those two issues. I wish not to go into details since we have the decision. Now, finally, on the facts. The facts are simple, and it is 6 pages of facts. I just highlight 2 or 3. The first is that the OB report, it is not contested. The OB report was laid on 21st of August 2023. The witness statement says so. The complainant testified so. But what happened is that in the charge sheet, another OV report is purported to be the source of these allegations. And this OB report is almost half a month later. It is on 6th of September 2023. And the funny thing is, it comes after the statement is already recorded. So according to the ODPP, the complainant went to the police station today, recorded a statement, and then tomorrow he made now the initial report. Of course, the issue of the presumption that arises when a party fails to produce evidence arises. The evidence was in the custody of the respondents. Again, Section 112 of the Evidence Act, that is the evidence within the special knowledge of the respondents, this applies. The only reason that they could not provide that OB report is because there is the truth of what happened. There was no offense that was reported at that point. It was an accident. But now, half a month later, this was changed. The other facts you see and they are in the petition is the forgery of a receipt for a laptop. And it is so obvious. The receipt is issued by a company, an unregistered company, you won't kite it. The company has an email address which does not exist and cannot exist. For you to register a Gmail email, you need 6 characters. These are only 3. It is impossible. You go to the medical reports, again, you find that a CT scan, which was supposed to have been done in August, it was actually done in October in a different hospital. Everything is a fabrication. You go to the witness statement, the complainant says that he was assaulted, taken to the hospital, and then locked in the house for 3 days. That is what his statement says. His testimony, he says that he was assaulted today, tomorrow he went to the hospital. There is no congruence. If I may finish, because everything is in the pleadings and in the submissions, the decision in Dande versus the Inspector General of Police, that is the Supreme Court decision. When a petitioner approaches a court through the Constitution for judicial review, it is under the Constitution, the court is allowed to make a merit review of the decision. So, apart from showing that ground 3, that the first information report does not disclose an offense, that this is an abuse of court process because the evidence is fabricated, on top of that, there is the reasonability. Is the decision unreasonable? Could a reasonable prosecutor have made the decision to charge? I will end there. Thank you.